Hey guys, thanks for joining. We're going to be talking about 627.736, a right to recovery in a tort claim, all right? So two things in this statute, in this part of the statute: no lien by an insurance company for the PIP benefits that they paid or are payable, meaning no subrogation. So that $10,000 in PIP money, the insurance company can't get it back. No insurance company can get it back. It gets paid out. Med pay, medical payments coverage, on the other hand, this does not apply to. So some insurance companies, they pay out the med pay benefits, right? So let's say I'm insured with a company that rhymes with like Snake Farm, okay? So, so Snake Farm, okay? So I have that insurance. I have a $5,000 med pay policy, okay? So, and I have a 10,000 PIP, all right? So I get in an accident. Oof, let's not wish that, but I get in an accident. There's 10,000 in PIP, 5,000 in med pay, all right? So the insurance company, let's say I get $1 million settlement from the gigantic truck that hit me. I get $1 million settlement, okay? The PIP insurance, State Farm, cannot ask for that $10,000 back. They can ask for the $5,000 back in med pay because there's no statute for med pay that says they don't get to subrogate the money, they don't get to take it back if there's a recovery made, okay? That's the first section. Second section of the statute says the court shall instruct the jury that the plaintiff, the injured person, doesn't get money back for PIP benefits paid or payable. We call that a set-off, a $10,000 set-off. That means that when every personal injury case starts off at a negative $10,000 or $2,500, there's no clear law on this because it says paid or payable. So if there's an EMC, they would get the $10,000 minus $10,000 or a set off of $10,000. And if there is, if there is an EMC, if there's no EMC, it would be, $2,500 paid or payable. It would be a $2,500 set off. That's if the case goes to court. Insurance companies always say, hey, if this case goes to court, we get a set off anyways. So they just automatically include it in the negotiations. So every case that a personal injury lawyer negotiates, whether it's settled or verdict, okay, to trial and verdict, every single case starts off at a negative because of PIP. So just to go on a little sidetrack here, personal injury lawyers, they want to get rid of PIP. Why? And that's not all personal injury lawyers, right? That's an exaggeration, a stereotype, but there is a movement in some personal injury lawyer circles to get rid of PIP. Why? Every single case that we settle as PIP attorneys starts off at a negative. Okay, so let's say it is negative 10,000 because we know that 99% of PIP claims have an EMC in them. Okay, so that means the personal injury lawyer is losing out on $3,333.33 on every single claim because it goes straight to the doctors, right? So as a personal injury lawyer, I would benefit if they got rid of PIP in that regards on my injury case. Obviously, I wouldn't be able to do PIP suits, which would impact me as well negatively. But for every personal injury lawyer out there, there is a movement, a small movement to get it as the law to get rid of PIP. And that's why is this negative, it's a $10,000 set off on every case. Every case has an EMC, so I'm just generalizing as $10,000. If there was ever a case where they only paid $2,500, you could, in theory, only get a set off of $2,500, but that's not going to help anybody, to be honest with you, to manipulate the case that way. But that's why personal injury lawyers, some personal injury lawyers, want to get rid of PIP, is a financial motive, okay, to get more money per injury case. Okay, I do PIP suits, so I'm happy to do PIP suits. I'm making a whole video section on PIP suits and PIP claims so that you guys can learn about PIP. So don't throw tomatoes at me through the screen. I'm just educating you about why people in the personal injury community want to get rid of PIP suits. Thanks for watching.